Chair recognizes Chairman King to lay out and consider House Bill 3445. Vice Chairman Darby lays out the committee substitute to House Bill 3445. I would ask you, Chairman King, to explain it.
Thank you, Mr. Chairman and members, for the opportunity to present this piece of legislation, proposed legislation. The Texas Property Code currently lacks language to discourage developers from prolonging development indefinitely, which can have a negative impact on homeowners in some homeowners associations. Without a requirement for developers to complete development and turn over the HOA to homeowners, some developers are increasing their declarant control or development period for many years past the initial projected completion date. During the development period or declarant control period, developers benefit from exemptions in the law that allow them to bypass provisions that offer common consumer protections in an HOA. Texas has an opportunity to lead the way in HOA reform. House Bill 3445 represents a step toward increased transparency and reduced opportunities for abuse of homeowners in HOA communities all over Texas. This time I'd be glad to answer any questions or turn it over to some folks that can do a better job answering those questions than I can.
Thank you, Mr. Chairman. The Chair will recognize Representative Beckley as being present. Members, do we have any questions of Chairman King? Mr. Chairman, we'll go to the witnesses and certainly recognize you to close. Chair calls on Vanessa Perez. Okay, you can give it to Isaac. If you just please state your name, tell us who you represent and your position on the bill.
Yes, my name is Vanessa Perez. I am a homeowners. I represent myself, my family, and also I represent an organization called Homeowners Voices United, which currently extends to about 500 homeowners in our neighborhood and also potentially thousands of Texans across the state if this bill were to pass.
And you're for this bill?
I'm for the bill.
Okay, thank
yes.
you. Please proceed.
Yes. Well, I just kind of wanted to give a little background. I really appreciate you guys taking the time to hear us, and I prepared some information that you can look at your leisure. I'm not going to read through it. I know I'm not going to be disrespectful of your time and go word by word, but I do want to give you a little background on what it is and why we're here today. I know that I'm here with 8 of my fellow homeowners, friends and neighbors that came with us today from Laredo. And I just wanted to thank Mr. Tracy King for hearing us, coming to Laredo and hearing us and hearing our situation, and subsequently assisting with this bill that addresses not only the issues that we brought up for our immediate situation, but also for other Texans all across the state. I know that this bill, I kind of just wanted to, if you look at the cover, I know I had my very talented brother-in-law draw the cover for this booklet. I don't know if you all can see it, but my idea for it was that, a lot of homeowners are drowning, and I didn't know how to communicate that message other than a visual. And I feel that with this bill, it offers a life buoy for a lot of people that are looking for some kind of relief, from what they're going through right now. And, we've looked a lot into the situation and what we can do, and a lot of the problems seem to point back to the laws, unfortunately. And if you read the first quote, it says, "These days, the American dream of home ownership has turned into a nightmare for millions of families. They wake up every day to the reality of a horrible decline in the value of the home that has meant so much to them." And homeowner associations are supposed to preserve home values. But what you have sometimes with developer-controlled homeowner associations is that you find that your home value is actually decreasing. And there's various reasons for that. I kind of just wanted to put out there some of the problems with, developers retaining control for a long time. It's not that we want to take away the privilege that a developer has to develop and build. It's just that we want to make sure that when they do that, they're making that there's a term limit to it. Because right now in the community that we live, we're going on 25 years of declarant control. We're not seeing any development, and we're seeing that are having a lot of problems because we're being asked to pay a lot of money in dues and we don't know where our money's going. We're not getting answers as far as, transparency, and we're not getting a good, clear sight as far as when the homeowners will have a voice, because currently the law only allows 1/3. And so realistically, 1/3 is pretty much not really a voice. When you're always going to be outvoted, it really doesn't matter what you're saying. So that's what we're experiencing right now, is that 1/3 of the homeowners, that's the maximum after 10 years, that's the maximum you're allowed right now as far as the law. And we feel that homeowners deserve more than that, because it's our money that's being used to run the association. 2 years ago, we ran into a situation where they raised the dues 70%. So a lot of homeowners faced hardship from that. If you look at the back of the booklet, you'll read some hardship examples that were caused from this drastic increase in dues. For a lot of people, that ever since these letters were written, a lot of these people have subsequently divorced and lost their homes to foreclosure. So this is a very real situation that a lot of people are going through. And I gave some examples of what exactly drowning looks like. If you look on page 9, 10, 11, and 12, you'll see that when you get behind a little bit on your association dues, you start to get tacked on interest and attorney fees, and you owe $5,000, and before you know it, you're owing $20,000. And homeowner associations are an entity, that one of the few entities that can foreclose on a homestead. So in a way, it becomes a taxation without representation situation, because they set the dues amount and there's no cap on the increases, because if you're a developer, you don't have to fall under a cap of increases. So they can basically, triple, quadruple, whatever percent they want to raise the dues. They run the board, so they set the amount. And if you can't pay it, then they put a lien on your home. And then if you can't pay the lien or whatever, then they can foreclose on your home. And this is very real for a lot of Texans, a lot of Americans, and it's very real for us in our community. And so we looked at the law, we looked at the sections where it could say, you know what, if developers are exempt from this section, then why are they exempt if they're using our money? So let's take away their exemption and make them, get bids, hold to a 10% increase, take into consideration the homeowners, voices, because right now we don't have one. A lot of homeowners don't have one because, you don't have any homeowners on the board. So, and if you're developing, then you don't have to give homeowners a seat on the board, only after a certain point. And what ends up happening is that you have to file a civil lawsuit to get any kind of remedy. And civil lawsuits are expensive, they're time consuming, and it's unfair to a lot of Texans to have to file a civil lawsuit when the Texas law could very well be written with consumer protection, transparency, advocacy a little bit more for the homeowner, instead of relying on the developer to just basically not misbehave. Is kind of what we're here today, is that, and I asked my son asked me, what is a bill? And my son likes to make up games where you make up rules. And I said, well, basically a bill is like a rules, but for life. And I said, well, why can't there be rules for developers that they have to stick to the same rules that a homeowner-run association has to adhere to, as far as when it comes to running, managing money that, we're all paying into. And so, putting records online and taking away a lot of the loopholes that you have to jump through just to get answers as far as, well, where are you spending the money? Why are you making the decisions that you're making? And it's not that we don't want developers to develop or we want to discourage that. It's just that we want to say, you know what, build a beautiful community and we're with you 100%. But when we're paying into this bank account that you're using, let us know where you're spending our money and let us know when you're going to be done. And if you say you're going to build something, just, let's try to make it happen for the betterment of everybody, and not just, say, well, you don't have a voice, and it's oppressive a bit. And that's basically, the other handout I gave you is an example of what can happen when you actually speak up and try to protest a decision that a declarant-controlled board makes. They can basically, just ignore you. I brought up a concern that the 70% was too high. They told me they didn't know what I was referring to because there's no law in Texas that requires them to have websites. So they shut down the website that had all the documents I was referencing. Then I sent that back, and so and it hasn't gotten anywhere. And so here we are, fighting in a civil court, but that's not really the bill. Isn't really just for our case. It's to prevent future new developments from staying in development indefinitely, or other homeowners across Texas that are going through the same problem and suffering in silence, or suffering from shame of not being able to afford their home because of dues, and then they move and they get out of the community, and then they just kind of leave the problem for other people to inherit. And so we just wanted to shine a light on that, and then look to see if there's flexibility in the law where it could be a little bit more specific and a little more pro homeowner, and not so much that it's homeowner versus developer, just a little more secure, so that when you buy your home, you don't have to worry, I can afford it today, but will I be able to afford it tomorrow?
Well, thank you for that. Members, do we have any questions? Vanessa, thank you for your testimony.
Okay, thank you.
Next chair calls on Alex Valdez.
Hi, good evening. I'm Alex Valdez, and I'm an attorney with Winstead PC. I'm here on behalf of the Texas Association of Builders to oppose the bill. I'm a board-certified Property Owners Association attorney. It's the first year of certification. There are about 30 of us in the state of Texas, but I've been practicing law for 17 years, and I represent a number of property owners associations, I believe over 100 property owners associations, and the majority of my owners associations that I represent are owner-controlled POAs, both homeowners associations and condominium owners associations. And I'm concerned about the unintended results or consequences of legislation. I've been involved in a lot of litigation over the years. One example of a case that I dealt with recently on behalf of an association came about as a result of the xeriscaping amendment to the law. There was a xeriscaping amendment to the property code that allowed an owner in a property owners association to install xeriscaping in their yard, and that was legislation that went into effect without any explanation as to what xeriscaping was. We dealt with an owner who wanted to put rocks all over their yard, and that's what they did, and we ended up in litigation, and we tried to move forward as quickly as possible. This owner actually had 3 different lawyers who represented him in that litigation and had an interlocutory appeal, and it was a bad situation for the association. It was bad for the owner as well. But that was an example of legislation where it had some good intent behind it, but really without understanding how the process would work as far as enforcing that rule. Unfortunately, it's just not gone over well with regard to my association clients and them trying to, regulate yards and adhere to the restrictive covenants. In this case, my concerns in particular are that we have a scheme that allows for, already under the property code, a transition of 1/3 of the board after 10 years if there's not a maximum number of lots. There are annual meeting requirements for all nonprofit associations in the state of Texas. All board meetings have to be open to the public, or at least members of the association. Even though there are carve-outs for the developer period, there's a laundry list of items in the property code that have to be the subject of an open board meeting, even during the development or declarant control period, if the board is to take certain action. Board members owe a duty to act in the best interest of the association, whether they're declarant appointed board members or whether they're elected by the owners. They're also required to post their agenda in advance of the meeting and provide notice to the owners based on the Texas BizOrg Code, Chapter 22, also the Texas Property Code. There's a petition process by which owners can require or force the board of directors to call for an annual meeting if they refuse to hold the annual meeting. Members can typically petition for a special meeting of the members, but the long and short of it is there are a number of provisions that are effective now, at least as far as the associations that I represent, to give us relief if there's an issue where we have to petition the court to force a board or to force the association to take some action.
So let me, turning your attention to this bill, I mean, on the substitute, with regard to the provisions that call for transparency, maintenance of a website, producing information on the website, what's your position on that?
I'm not concerned about transparency. Transparency, owners are entitled to the information, they have to submit a request, but they're entitled to get, basically any records of the association need to be made available to them within 10 business days of receipt of that request. And the fees that are to be charged are based on the Texas Administrative Code's provisions that pertain to open records requests, so they're fairly nominal. In most cases, I'm dealing with responding on behalf of an owner-controlled association, and we're struggling to gather up a lot of information. We typically have to pay a manager to get
And
that
on this
information
substitute,
together.
these documents will be published and maintained on a website.
I wasn't prepared to address that, but I can speak to the issue.
Well, I would
think-
appreciate it, because that's what the substitute is mostly about. So I would hope that you can address that.
Sure. So typically, well, right now, there is the website requirement as far as maintenance of governing documents, and the governing documents are documents that are filed of record. They have to be recorded, because under the property code, you can't enforce a rule as an association unless it's been recorded. And so the same documents that are required to be posted now are also found, they can be accessed through most of the county records websites. This expands that information, and so, or expands the amount of information that needs to be made available online. In my experience, providing information online, a lot of associations that I represent already provide that information online, or it's available on request, or it would be produced at a meeting. So by making that available online, it is adding some administrative burden that would result in additional management fees, to have to process. and
So
upload.
I'm clear, all the members of the association could make a manual request for these documents and have a right of access to them, provided that they meet whatever administrative requirements that are in statute. What this substitute is saying, rather than do that, you make them accessible for one and for all on a website, which I think reduces your workload and your administrative burden. And so I'm just, for the purposes of the author of the substitute, I want to narrow this down for him. Are you all okay with that provision of the substitute that calls for making these documents, producing them online, and making them available for those, in addition to the ones that are required to? But on page 3, line 9, regarding board meeting and minutes of the board meetings, they'll also be placed online within 5 days after the conclusion of the meeting.
We have a position with regard to the transition from declarant control.
Well, let's get back to my question. My question is about these documents
Oh, right, no,
and
no.
making them publicly available online. And you said you don't have a problem with the transparency. I'm trying to figure out what pieces of this bill that we might be able to work towards in terms of finding a solution. And are you okay with that?
I'm sorry that I'm not being very clear. I don't have a position on that,
Okay.
but personally, I'm okay with that. I'm okay with
Well, I don't need your
transparency.
personal, you're here on behalf of the Texas Association of Builders.
That's correct.
That's where we're going to hold your testimony accountable to the Texas Association of Builders. So your personal opinion really doesn't have a lot of value for me. My question is this, this seems to be a big transparency piece in this legislation Chairman King is working on. It's my job to sort of flush out what the issues are so that I could advise Chairman King on how he might be able to repackage his legislation to garner the support of this committee. And a big component of it deals with transparency and making documents available online, as well as board meeting minutes. And I need to know if that is something that you oppose, or are you for?
Oh, I don't have a position. We're neither opposed nor for it. It would have the same impact on a developer-controlled community as it would have an owner-controlled community.
So you're opposed to the bill, but you're not opposed to that?
Correct.
Okay, thank you. And then there's another piece with regard to the composition of the board going from 1/3 property owners to a majority. I'd like to know your specific position on that.
Yes, we're opposed to that.
Okay, and tell me why.
You're talking about the transition of the majority within 5 years if there's not a maximum number of lots?
I'm talking about section 5, line 21.
Correct. It's a one-size-fits-all approach that might work well for a smaller community, but wouldn't work well for a large community. In most cases these days, the larger subdivisions are phased in over time, and so it's just too difficult, too cumbersome, and too expensive to have the development plan submitted to the governmental entity and have everything, have all of the property subdivided before you break ground or transfer the first lot. And so it just wouldn't be workable for the vast majority of modern developments that are large in scale and scope.
Do you have any suggestions on how we might be able to tailor some language so it's not necessarily a mallet that would apply to all circumstances, but perhaps some sort of test or criteria that must be met before you can transition from a board of 1/3 property owners to a board that is a majority property owner board?
The current statutory scheme, I think, works well.
Well, the current scheme is 1/3, and I think the
Correct.
proposals for majority, your response to that is that it's not workable in all scenarios, which I'm willing to spot you, but in return, I need you to give me some guidance on how we might be able to apply it, in what instances will it make a good idea to have those associations transition over to majority property owner board.
It's difficult to come up with just a single approach and apply, in blanket fashion to all of the communities just based on the variations.
I would agree with you, except for the fact that we have a blanket provision now.
Correct.
And so if it works in one conception at 1/3, and there seems to be a discussion about moving that to another blanket provision, I'd like to maybe engage your thoughts, and if it's okay, you can give me the answer offline if you want some time to think about it. You don't have to have an answer right now.
Sure. Well, the comment I would make right now is, I guess one of the issues with the proposed legislation also is if someone were to come up with an inflated number, simply to make sure that they have the opportunity to hang on to control for as long as possible, I think that's a shortcoming of the proposed legislation as well. So perhaps if you had some percentage maybe tied to the majority transition, so the majority of lots or 75% of lots that that can feasibly be developed to where it is actually tied to some type of development standard, and usually they'll have some idea based on the density requirements. And I think in this case, and I want to mention too, we're not against Laboda or the owners that you've heard from or the owner that spoke this evening. We're certainly sympathetic, and so we're not defending that developer.
Sure.
But I think that you have to take into consideration just the feasibility based on the fact that someone would be able to put an inflated number based on the proposed legislation.
Okay, well, I appreciate it. I don't think you've testified in this committee before, and for other witnesses that will follow, it's sort of the intent of this committee to make sure that stakeholders meaningfully engage with the author of a bill and work, in an expeditious manner to sort of narrow the issues and see if we can come up with some language. And I often will ask the author of the bill to keep the committee apprised as to those conversations to make sure that they're actually happening. And if they're happening in good faith. And so if you would just do us the honor of getting the opportunity to visit with Chairman King on these issues and see if we can find some middle ground on it.
We've offered to do that. We have met with him, and we've also met with the Laboda owners this afternoon to talk through some of those issues and to see what sort of support we can offer them. Okay. And so we'll continue those discussions. I've provided my information, and we intend to have some follow-up discussions just to see how we can address their situation as well.
Appreciate that. Members, do we have any questions? Chairwoman Collier has a question.
Yes.
So I just want to get clarification on how the process works now. So if a developer has the control of they spend money to, plot out the land and all that stuff, and they create the development of the property. Mm-hmm. So at what point does it transition over into allowing the homeowners to have a part in the process of being, stakeholders or board members? Is there something in law right now that says after 5 years, because I heard you say something about 5 years, and without, if a certain number of lots aren't there, is that when that trigger of the 1/3 is right now?
That's right.
So right now, if they don't have certain number of lots
Well, not 5 years.
Oh,
A maximum number of lots, 75%, they're required to transition at least 1/3 of the seats. And by transition, we mean they have to call a special meeting of the owners, so the owners get to select or get to elect a director to serve on the board. If there is not a maximum number of lots that may be developed, then the default rule is after 10 years after the date that the declaration is originally filed, they have to call that special meeting to transition at least 1/3 of the board.
okay, so that's 10 years.
Correct.
Okay, and so I think that what Chairman is asking is there a certain way for us to get that number? I mean, what if you did lower that number? And then on the other side, my mind is thinking, well, if you're developing the property, you want to make sure that it's in a certain, you want to make sure that it stays a certain way, so that way you can go market it to potential investors, right?
Correct.
And so that's what your concern is. It's like we want to make sure, and that's why developers want to have the control, I'm sure, is that we're still marketing this. We're still doing phase 2 and 3, so they want to have control over it. But at the point where you have 75%, whether that's 2 years or 5 years, would you be amenable to say, okay, whenever you get 75%, wouldn't that be the trigger to make sure that that's the majority?
Right, and the reason why I was struggling a minute ago and coming up with just some alternative language to present or to consider is because the way that the bill has been drafted, you have essentially a default clause that says that if you don't have a maximum number of lots, there will be this automatic transition after 5 years. And so if you have the maximum number of lots in there, then it goes back to the 75% conveyance of sort of like the way the way that the statute is set
Well,
up
to me,
now.
if the developer hasn't done anything in 5 years, it seems like they've given up, and the homeowner should take over and take ownership of their property and be the ones that be proud of their property. So if they want to do that, I don't see what the issue is. In 5 years, if there's nothing done to sell, I'm just trying to figure out, wouldn't they have a role of pushing the process forward?
Right, but my point is that right now, if someone were to put a maximum number of lots in there, even if it's an inflated number, it would still be a way to avoid, the transition after 5 years, because that's a default rule that only applies if they don't have the maximum number of lots that can be developed. And so what I was struggling with a minute ago was just on the fly trying to maybe think of a suggestion to deal with what is really feasible. So, for example, if I have a 10-acre piece of property and I can't possibly put 200 lots on that because I know that the local regulations only allow for density of 4 lots per acre or something like that, I think it would be realistic to impose some sort of requirement that's also tied to the feasibility with regard to what you can actually do with that piece of property. So trying to balance just the conceptual nature of modern development process where you're saying, okay, well, we need some flexibility to perhaps put a condo on this tract over here and then maybe have larger lots on this one piece of land. And so trying to come up with some type of an estimate on day one as far as how many lots you might develop, and so at what point in time you'll transition, trying to find some way that focuses on feasibility. Otherwise, it just gives someone the opportunity to put, again, a vastly inflated number in there simply to end up in the same situation where you have owners who just don't have the opportunity to participate in their own governance scheme for many, many years because of the fact that the owner, the original developer, has no intention of developing the property further, probably has just a small piece of land that they can't possibly do anything with, and yet they're still in control of the board. So there are a number of ancillary issues. I mean, in this case...
But in that case, wouldn't you think that the homeowner should have the right to take over then?
Yes.
Okay.
But I'm saying that the legislation right now, the way it's drafted, is not, it would not effectively address that situation if they were to put in an inflated number of lots.
If they said, we want 200 lots and it really can only accommodate 50.
Correct. Or, yeah, if they just have 1 acre left, but they still have this number of, 200 lots that may be developed.
Well, I can certainly understand the goal of trying to complete the development, and you want it to be marketable, the developer does, because they've made a large investment in it. But at some point, it seems that the right thing to do is to turn it over to the homeowners who also have made their investment, and if they're the majority there, 75%, at that point, it just seems like that could be the trigger. But I don't think that you're saying completely no, And I think what the chairman is trying to say is where can you come together? And I think that if you keep talking about it and keep thinking, you'll get there.
Correct, and I agree with your point completely. It's just the struggle of coming up with some type of formula that would generally apply and be fair for everyone without creating an opportunity for someone to simply avoid that rule by just, plugging in a much higher number than, they can actually ever accomplish in reality based on the zoning or planning requirements.
Thank you, Chair Collier. Chair recognizes Representative Moody's being present. Vice Chairman Darby has some questions for you.
Yeah. Laboda, I just pulled up the pleadings of the lawsuit filed in 17, and I've read some egregious actions with regard to homeowners associations. But this probably takes the cake. What are we to do? We have some folks here that are trapped. They're trapped in a situation where you've got developers who are acting in their own self-interest, it appears to me, and not in the self-interest of the property owners. And I understand your concern about making broad policy decisions in statute that may overreach in some cases and some not. But we're going to have to strengthen the ability of homeowners when they are being abused, as I suspect these folks that live in this subdivision are. If even 10% of the pleadings are truthful. What are your suggestions? Instead of saying what not, how are we to sort this out?
A great example of, I think, some of the problems that you can have with legislation. So in Laboda, those documents refer to a master plan that was never recorded, but the master plan actually refers to, I think, 2,400 lots that can be developed. Is that the maximum number of lots? Is that the number that would be plugged in such that they're able to take advantage of that other clause? Again, I think it goes back to feasibility. If you look at the map and look at what they've done, I think they've conveyed most of the usable land, and the only piece of land that they have left as part of that original master plan is what they had initially reserved for the golf course because of just the elevation changes and not being feasible. So I think if you go back to just the feasibility issue and look at realistically what they could have done and hold them to the maximum number of lots that they really could have developed, then I think they're well beyond that threshold transition. At a minimum, in 1995 is when their original declaration was filed, so they should have transitioned at least 1/3 of the directors in 2005. And so there's no reason they would be able to proceed without holding an annual meeting. They should have had an annual meeting even before the first lot was conveyed if they had the nonprofit association up and running at this time. I think a lot of the allegations in that case pertain to the developer's family members serving on that board who are also entering into contracts with their development entities or shell companies that they own or control. And that I don't know more about
broadband
the
or
case,
maintenance or any other number of ancillary missions that the homeowners are having to pay for to developers' family members.
Right, and so there's a Texas Business Organizations Code provision, Chapter 22, that restricts an interested director transaction and sets a pretty high threshold as far as the type of deliberations, the voting requirements for something like that. And so it seems to me that, at least based on the pleadings, I've seen allegations about a number of things that I just frankly don't think are permitted under Texas law and are dealt with in some remedial fashion based on the statutes that are in effect now.
Well, our job is to try to make some sense out of this and try to not be overreaching with regard to our policy, but to address legitimate concerns. And there appears to be a legitimate concern with regard to the type of practices that this developer is perpetrating on the homeowners that live there. So we welcome your continued. Now you're here on behalf of the home builders, right?
That's correct, and we don't condone that type of development behavior or activity. We just want to make sure that the climate is still good in Texas to attract, the investment dollars and developers who want to come here and build those large subdivisions in a responsible fashion.
And following the chairman's comments, you are meeting with the bill author to address the concerns that this bill is trying to fix.
That's correct, and we've communicated with the lawyer representing the owner group. We've communicated with the owner group, and we've committed to continue to do that to see what we can do and offer our assistance.
Okay, thank you, Mr. Chairman.
Members, do we have any other questions? Alex, thank you for your testimony. You're one of the few that actually registered to testify, and so it was important for us to, we had to throw all the questions at you. You're the only one that had the courage to come up and testify against the bill in person, so we appreciate that, but we certainly are looking forward to getting an update from Chairman King as to these conversations. We'd like to be in a position to learn this issue a little bit better and perhaps be in a position to help. So
Sure, and I don't know, you'll have to forgive me, I wasn't very familiar with the process, but I'd be happy to come back up and visit with folks one-on-one if they have any questions about, my experience in dealing with some of these provisions and how they play out in litigation or representing associations, because I do have concerns about some other areas.
I think in the short term, it'd be great for you to get with Chairman King, and then we'll members of the committee are pretty good about getting the answers to their questions, so they may just call you.
Sure, I appreciate
Okay.
it. Thank you for your time.
Thank you very much. Chair now calls on Guillermo Castro.
My name is Guillermo Castro Jr. I am a homeowner, part of the Voices United, Homeowners Voices United. The thing that comes to me right now is...
I'm sorry, Mr. Castro, just for my record, you're testifying on behalf of yourself only?
What was that, sir?
You're testifying on behalf of yourself
Yes, sir.
only, and
Yeah.
you're for this bill?
Yes, sir.
Okay, thank you. Please proceed.
The thing that comes to me and mind right now is fairness, transparency, and justice. This bill that Representative King is introducing on behalf of us, not only on just behalf of La Bota, but all of other homeowners that are in this same situation. This is an epidemic that goes unheard of because people are afraid to come up and face it. We face losing our homes because we didn't pay our mortgage or the tax man. But can you believe for not paying for unjust dues? This is the thing that faces us. Vanessa has done a good job by putting broken dreams. The American dream is always owning a home. And that's what we have, our nest eggs, memories. Our state is a home, and we protect it, Our nation is our home, and we have soldiers that die for that. We pay the ultimate price. We're not on this, this bill can be tweeted. We can do stages, but when you have what they call it, road, developers, homeowners, self-interest, there's got to be a law. There's got to be an enforcement part of our state that enforces those laws to protect these homeowners. Let us be the state that moves forward in protecting homeowners. Transparency is a must. We all talk about it. Let us move forward on doing this. And I guarantee you'll brighten that light. When we came here today, we heard negative, oh, it ain't going to pass, they're going to be fighting for it. But we came with a light of hope at the end of the tunnel. You gentlemen proved it today. There is justice. I thank you for that. Any questions?
Yes. Members, do we have any questions? Guillermo, thank you for your testimony. Appreciate that.
Thank you, sir.
Thank you. Is anybody else here wishing to testify on, for, or against committee substitute House Bill 3445? Seeing none, Chair calls on Chairman King to close on his bill.
Thank you, members, and thank you, Representative Darby, for reading those pleadings. It's far better. For those of you that didn't get a chance to do it, just very, very briefly, some of the things I thought maybe somebody would speak to it earlier. First of all, let me say that the folks that own this particular, the developers are local folks. They own all of the ranch land or most of the ranch land around this area. They've been in the community a long time, and they're nice people. They're good people, but this particular deal has been in the declarant stage for something like 25 years. Since they own all the property around it, they can make a case that has yet to be developed, so they'll never get to the 75% threshold. I'm going to get my facts a little bit off here, but the soccer fields and some of the athletic fields that are for use of the Homeowners Association are actually owned by the family. They're not owned by the Homeowners Association, but the family leases it. The developers lease that land to the Homeowners Association for $6,750 a month. Most of the maintenance contracts, all of the security contracts, all of those types of things, all of those companies that do business with the Homeowners Association are owned by the developers. The attorney for the Homeowners Association is one of the family members that is one of the developers. It's a husband and wife, one of their children, their son, and an ex-brother-in-law, and some others, I suppose. But so it's just one of those kind of situations where that's the situation that you have. I'm told by builders and people that are involved with Homeowners Association, be candid with you, this is the first Homeowners Association bill that I've actually had any work with at all in the 24 years I've been in the legislature. But I realize this is perhaps a very unusual situation, but it doesn't mean that they don't need help, and they need a voice. They've traveled up here today, and I'm so grateful for their presence here today and all day long. We wouldn't wish watching us work all day long on anybody. But I thank you for your attention. I look forward to working with the gentleman that testified earlier for a solution to this problem, and so that these homeowners can feel like they have a real voice on this particular homeowners association. And with that, I'll be glad to answer any questions that any of the members may have.
Thank you, Chairman. Members, are any questions? Chairman, keep us apprised on those conversations, and we'd like to know, how we can help you with that bill. Okay.
Thank you. And again, I appreciate you reading that pleading. I could tell in your voice that you were a little shocked.
Well, I mean, one thing, a lot jumped out at me, but they unilaterally declared their control over the board to be extended to January 1, 2050.
Yes, sir.
Long after we're going to be gone. They're going to have control over these folks, and they unilaterally extended that without any homeowner input.
They were able to do that. They had control of the board. It was them. So, anyway, that does stand out at you. With that, I close, Mr.
Thank
Chairman.
you, Mr. Chairman. At this time, the chair will withdraw the committee substitute to House Bill 3445, and the chair will leave House Bill 3445 pending. Any objection? Hearing none, the bill will be left pending. Chair recognizes Representative Parker as being present. Next, chair recognizes Representative Bohack. Lay out and consider House Bill 1025. Members, for planning purposes, it's the chair's intention to go to Representative Vo next, Representative Murr after that, and Representative Bonin if he's still here. Representative Bohack.
Thank you, Mr. Chairman. It's a pleasure to appear in front of this committee. I've served on this committee under Representative Oliveira